and gentlemen, Joy Stephen from the Paulinson Studios, and here is another case law for the Student Herald. Canada versus Gezik. Case law is not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog, reportersreport.com, as a PDF document. Now, this is an immigration case law and includes topics like refugee status, procedure. Foreign national and wife who were citizens of Iran went to Turkey and filed application for permanent residence based on refugee status outside Canada. Foreign national's wife was principal applicant and foreign national was dependent. Foreign national received positive determination in category of Convention Refugees Board Class CR1 and became permanent resident of Canada based on wife's well-founded fear of persecution for reasons of religion. Foreign national subsequently renewed his Iranian passport at Iranian Embassy in Ottawa and took 2 trips to Iran with intention of returning to Iran again to get married as he had divorced original wife. Minister applied for cessation of foreign nationals' refugee protection pursuant to S 1081A of Immigration and Refugee Protection Act of Canada based on foreign nationals' reavailment of protection of his country of nationality. Board concluded that plain reading of S 951A of Act indicated that someone can only become refugee if they are determined as such either by overseas visa officer or in Canada by Refugee Protection Division. Consequently, Board found that foreign national became member of CR1 class pursuant to S 140 of Immigration and Refugee Protection Regulations of Canada by virtue of being his wife's dependent and not as a result of being determined to be convention refugee. Not being convention refugee, Board concluded it had no jurisdiction under S 108 of Act. Minister applied for judicial review. Application was dismissed. Language of S 95(1)A is clear, particularly when informed by similar language in regulations of OP5 manual. Provision speaks only to persons determined to be convention refugees or similarly in need of protection. If entitlement of CR1 classification are to be limited or withdrawn from family members as a result of their conduct, this must be effected under clearly stated provisions so as to avoid any unintended misfortune from occurring. Question certified, i.e. where person has become permanent resident under visa application in overseas refugee and humanitarian settlement program by virtue of members of person's family listed in visa application having been determined to be convention refugee, though person was not themselves assessed as convention refugee. Is that person convention refugee as contemplated in S 95(1)A of Act who is subject to cessation of refugee status pursuant to S 108(2) of the Act. Very interesting case. Canada versus Gezik. It's dated November the 13th, 2015 from the Federal Court. Thank you.